Good morning, everybody. I'm Matthew Sheridan. I'm with Newmark Knight Frank in San Francisco. I'm a commercial broker specializing in apartments, mixed use, and commercial buildings. If you have any questions on the market these days, please chat with me afterwards. Happy to talk to you about that at a later point. Today, our guest is Stephen Williams, partner of the law firm Fried & Williams. They're landlord tenant specialists. They also do real estate transactional work, along with TIC, condo, things like that, work like that. They have offices in Oakland and in San Francisco. Many of my clients are clients of Fried & Williams, and certainly they're one of the best law firms in their field in town. Today we're going to go over a lot of different items related to managing and owning apartment buildings in the city and in California in general. As we all know, with the shelter in place that was imposed locally and statewide, we've seen a dramatic impact limiting business activities and employment. And that in turn has led to massive layoffs across the country. And most notably in San Francisco, it was just revealed last week that 44,000 San Franciscans have already filed for unemployment. And all that disruption has led to concerns governing the ability for some residents to pay rent, and that in turn has led to our policymakers to enact a plethora of regulations. These seem to change almost on a daily basis. And Steve's here to walk us through what we know up to date. And I'm sure, as I read this morning, there's something even more, there's more coming down the pipe. And just a reminder, if you have a question, please send that via the Q&A icon at the bottom. I'll receive that, and at the appropriate time, I will pose those questions to Steve. And so I know, Stephen, do you want to go ahead?
Sure. Thank you, Matthew. So first, again, thank you for having me. I did do a talk with Matthew just about 2 weeks ago. And, I get clients who are frequently asking, hey, what's the current state of affairs? What are the current laws? And there's so many different layers to the laws that impact property owners and managers and landlords. That it's, I parse through it as best I can, and I give my opinions and let you know what the law says. But then I say, well, call me tomorrow, because there's probably going to be something different. And just, like Matthew said, there's more things possibly coming down the pike as well. Since I did the talk with Matthew about 2 weeks ago, there have been some further local changes as well. Like most of you, I am at home right now working, remotely as best I can. I have a couple of young kids, a 7-year-old, a 5-year-old, who I'm trying to quarantine to a different part of the house, but sometimes they escape and they make it over here. And so I just want to let everyone know in advance that there may be some slight noise interruptions, but we'll get through it. So we're going to work through this as best we can. So yeah, let's get started here. So, of course, the topic is COVID-19 and how that impacts the landlord-tenant world these days, and specifically in San Francisco. So just first off, I'd just like to give just a general overview. Of course, the state of emergency back in, I think it was in March, Donald Trump declared a national emergency, and most, if not all, the states have also made their own emergency declarations as well. And this is important because certain laws are triggered when there's a proclamation of a national emergency. And I'll get into that in a little bit as well. And of course, in addition to the emergency order, the state of emergency orders or declarations, there's also stay-home orders where, most of the states, again, if not all of them, have implemented some form of a stay home, and California, of course, has done that as well. And generally, when there has been that order issued, you literally can't, you're not supposed to leave your house except for essential business activities, essential type of activities, which are outlined in the various orders. And I understand that some of those activities are being, increased. So you're slowly the limitations on what a person can do when they leave the house are relaxing a bit. So there's additional things that people can do. And again, this impacts the landlord-tenant world as well. And we'll get into that a little bit later. As I mentioned, when there's an emergency order declared or state of emergency declared, then certain laws are triggered in California. The anti-price gouging law is one of them that's triggered. And now this is triggered, of course, by the governor's state of emergency order, but these anti-price gouging laws are actually criminal laws in the penal code. You cannot charge, a person more than more than a certain amount for certain goods and services, and that includes rent increases. It includes a vacant unit that where a tenant is displaced during the state of emergency, and then the next tenancy. So basically, what it is a landlord during a state of emergency period cannot charge rent or a rent increase of more than 10%. You can't give a higher than 10% rent increase. Now, of course, in San Francisco, you're limited in any event, for the most part, most landlords, from increasing the rent even 10%. But for those properties that are exempt from local rent control, you need to be cautious and not charge a higher than 10% increase. Similarly, if a tenant gives notice and vacates during the state of emergency order, and the unit's vacant, generally you can charge market rate to the next tenant. Again, part of the anti-price gouging laws limit how much you can charge the incoming tenant during the state of emergency. And that is, you can't charge the incoming tenant more than you could have charged the tenant that departed, which means more than 10% of that tenant's rent. And these are generally in effect under the penal code for 30 days, unless they're extended by by the issuing government. So I mentioned that the California issued a state of emergency. Well, so did San Francisco, and those same penal codes are triggered by the proclamation of a local government entity also issuing that state of emergency. So long as those are in effect, you need to be cautious about your rent increases. And I'm going to also get into a little bit later a limitation on local rent increases as well in San Francisco. So we'll talk about that more in a moment. So first, we talked about the state of emergency and then the limitations on rent increases as a result. And I still have that typo. I forgot to correct it up there where I spelled evictions wrong. But so there's a statewide prohibition or moratorium on non-payment of rent evictions. Basically, what what Governor Newsom has done is basically stayed or continued all non-payment of rent type evictions, really for an extended period of time, for the at least through May 31st. So basically, when a tenant, when you have a tenant who's paid rent prior to the enactment of this moratorium, these laws apply. So the tenant must notify the landlord before the rent is due or within 7 days. And if the tenant does so and retains verifiable information that they're unable to pay the rent due to the coronavirus, then the sheriff is not going to enforce any evictions of that tenant for non-payment of rent. So basically, through May 31st, you cannot evict a tenant who's unable to pay rent due to the coronavirus, and they have followed these protocols. They've given you notice within 7 days of the inability to do so, within 7 days of the due date. Now, again, this is just a statewide moratorium. The local moratorium on non-payment of rent evictions is much broader. So most likely you're not going to be implicated by this because as you probably know now, most every unit in San Francisco is subject to San Francisco's just cause for eviction ordinance. Recently, actually effective this year, the just cause for eviction laws were expanded to include virtually everything, all new construction. So if you just had a property that was built within the last 15, 20 years that was previously exempt from just cause, it is now subject to San Francisco just cause for eviction ordinance. So because of that, you're going to most likely your property is going to be subject to the local moratorium on non-payment of rent evictions, which I'm about to get into right now. But before I do, I did see a couple of questions pop up. Matthew, did you have some questions? Nope, you're on mute, Matthew.
We're not quite there yet.
Okay.
I'll bring him in at the appropriate time. Thanks, Stephen.
Okay, got it. All right. So let's talk about the San Francisco moratorium on non-payment of rent eviction. So these are the residential. So first, let me just preface this. Like I said, the laws are changing, it feels like daily. So this part of the presentation was different when I gave it a week and a half or 2 weeks ago than it is now. On April 30th, it was, the mayor signed a new amendment to the non-payment of rent moratorium that changed the laws. So essentially, here's the general outline and overview. So for rent that becomes due after March 13th, so really what we're talking about is March through today and going forward, any rent that was due after that date, the tenant must notify the landlord of an inability to pay rent due to financial impacts related to COVID-19. Now, I put financial impacts and related to COVID-19 in quotations there. I'll get into those definitions shortly. But basically, the tenant gives notice of inability to pay. Before April 30th, there was a requirement that the tenant do so within 30 days of the rent being due. That's no longer the case. So the tenant can let the landlord know at any point. So I have clients who are saying, look, the tenant didn't pay all of April. What can I do? Well, before, if more than 30 days had passed, that tenant didn't get the benefits or protections of this moratorium, but now they do. There's no longer a 30-day notice requirement. So at any point, tenant comes forward, let's say it's June, they haven't paid rent since March or April, and they say, hey, I couldn't pay it because of a financial impact related to COVID-19, and they're going to get the protections of this moratorium. Now, it also says that the tenant shall provide the landlord with supporting documentation. And what does that mean? Well, what the law said before is that they had to provide objectively verifiable documentation or information within 7 days. Again, that's no longer the case. While they are required to provide the landlord with documentation, failure to do so no longer precludes the tenant from getting the protection of this moratorium. They can raise it later. So if a landlord doesn't get that verifiable information and decides to proceed with a non-payment of rent case against the tenant can provide it to the court and say, here's my documentation. And then the court can then say, all right, the non-payment of rent eviction cannot proceed because that is an affirmative defense to that eviction. So that's a significant change that before the tenant was required to provide evidence of inability to pay. Now, while they're required to do so, if they don't, it doesn't preclude them from later raising it in defense of a non-payment of rent eviction. So really, this kind of gets to the heart of what I've been telling landlords and property owners all along is you probably really shouldn't focus on, requiring the tenant to provide you concrete, hard proof of the impacts, the adverse impacts of COVID-19, because let's face it, every one of us has been adversely impacted one way or another by these circumstances. And so I've been, telling landlords and property owners to focus more on trying to come up with a payment plan, trying to get some rent from the tenant. And I'll get a little bit more into that later. But at this point, you should no longer demand that the tenant provides you with that documentation. Now, certainly the tenant is supposed to, and you can request it, but I would not hold up any negotiations or payment plans on the tenant's production of that information or documentation. So let's say the tenant, virtually once the tenant gives notice of inability to pay due to the financial impacts of the coronavirus, the tenant automatically receives 6 months from the expiration of the moratorium order to pay the rent. That's not 6 months from the rent due date. That's not 6 months from any other period except the expiration of the moratorium, which my calculation right now is the end of June. So 6 months after June, after the end of June, is when that rent is due. Meaning you're really looking into January of 2021 before you can expect that rent payment or take action if you don't receive it by that time. And again, these are subject to change. So again, the tenant triggers this, this automatic extension or opportunity to pay the rent to 6 months. If so long as they have told the landlord, I can't pay due to the coronavirus, that's an affirmative defense to any non-payment of rent case. So if you're seeking any rent during that 6 month period after the moratorium expires for rent that was due during the moratorium period, you're most likely going to be out of luck because that will be an affirmative defense to that non-payment of rent case. And another thing, and this was in the prior version of this moratorium, is the landlords are encouraged to negotiate a payment plan. But you cannot the tenant cannot waive the protections of this moratorium. So that means that you can't require the tenant or negotiate that the tenant pay it back in 4 months. Or even if you do, and the tenant doesn't comply with that, that's not a legally enforceable document. The tenant is going to have the full 6 months no matter what. So what the mayor is saying is negotiate for even more time, really beyond that 6 month period. And then that type of an agreement would probably be enforceable.
So Steve, I have a question. I'm a little confused. So the tenant essentially doesn't ever have to inform the landlord of COVID-related issue regarding ability to pay rent?
Yeah, they do have to give notice of inability to pay rent. What they don't have to do now is do it within 30 days of the rent due date, as was the previous moratorium law. And they don't, even though they're supposed to provide documentation to verify that, the way I'm interpreting this is they don't really have to anymore. They can, save it for later and use it as a defense to any non-payment of rent that came due during the moratorium period. So there is still that one main obligation of the tenant to give notice. But a lot of times that notice may not come until after the landlord, 30 days or 45 days later, says, hey, what's going on? I haven't received the rent. Then the tenant says, oh, well, I can't pay due to financial impacts of COVID-19. That would be a sufficient notification by the tenant, in my opinion. So I said I would give you the definitions of those key terms, financial impacts and related to COVID-19. You'll see it's very broad. So financial impacts means a substantial loss of household income due to business closure, loss of hours or work wages, layoffs, extraordinary out-of-pocket expenses, which probably a lot of us have at a minimum, out-of-pocket expenses. And then related to COVID-19 means the financial impact was due to the pandemic, the mayor's proclamation, local health officers' declarations of emergency, or any orders related to COVID-19 by any government authorities. So again, pretty broad. All right, let me just make sure I went to the right one. Okay, so that was just a summary of the, oops, I keep accidentally of the non-payment of rent moratorium for residential units. There's actually a few more points to talk about. So again, so this applies to any unit that is subject to the San Francisco rent or eviction controls. And as I mentioned earlier, virtually all units are now subject to at least eviction controls in San Francisco. Can't charge any interest or late fees for any rent that's deferred during this time. And nothing in the moratorium relieves the tenant of the obligation to pay rent, or a landlord from initiating a different type of a lawsuit for the collection of rent, like a small claims court case or any other general civil litigation. The moratorium expressly speaks to non-payment of rent evictions. And again, the moratorium expires on the earlier of June 29th, or the termination of the declaration of the emergency, or upon order of the mayor. I don't foresee anything shortening that period of June 29th, but instead possibly and most likely extending it. So it's already been extended twice. It initially expired April 22nd. It was extended to May 22nd, and now it's extended to June 29th. Again, I foresee it very well could be extended further. So I believe that's my last slide on the non-payment of rent moratorium. So any questions, Matthew, at this point on those?
Yeah, we do. There's a lot of concern. Sorry, there's a lot of concern about the 6-month term and what happens. So for example, say there was already a payment plan negotiated previous to this recent change that is relatively new. What happens in that situation where, let's just say April and May were deferred with a payment plan starting, I guess you said it's 6 months after the expiration of the emergency order. Is that correct?
Correct.
And so in that case, let's say there were 2 months of missing rent, it would be, and the emergency order was ended in, say, July 1st, you essentially have until January 1st to remedy the past due.
That's right. And so, yeah, this has always been a concern of mine for these, so the mayor has said in all its earlier orders, hey, get out there and try and negotiate in good faith. And a lot of landlords did, and they got these forbearance agreements signed by tenants agreeing to pay the rent over a period of 6 months, and everything was negotiated in accordance with the prior mayor's orders. I see this now as superseding those. So perhaps it doesn't necessarily mean that you run out and renegotiate with the tenant. Perhaps the tenant will still honor that that forbearance agreement that they signed. But if they don't, you can't enforce it. They're going to still have the full time, which essentially is roughly January 1st, give or take a few days, to repay all that rent, even if you previously in good faith negotiated that they would pay it in a shorter period of time. At least that's my interpretation and reading of this. And again, a lot of this is pretty, again, things are changing and there's a lot of different interpretations and opinions. Someone else may disagree with me, but I interpret this to mean that yes, if you did negotiate something and let's say that they were going to end up paying it all back by December 1st, that would be superseded by this, and they would actually have until now January 1st. And again, that could be changed by a subsequent mayor's order. And one other point I wanted to make is the non-payment of rent moratorium and deferment only applies to rent that's due during the moratorium period. So let's say that the moratorium actually does end at the end of June, and so July rent comes due, that July rent would not be subject to the moratorium, again, unless it's extended. So that July rent, you could ask the tenant to pay that rent in full. And if they don't, that could be subject to a 3-day notice to pay rent or quit. There's no deferment on that. There's no, ordered deferment on that rent because it became due after the moratorium period. In the meantime, so you're demanding July, August, September, that rent going forward. Meanwhile, the rent that fell due during the moratorium period, they've got the full 6 months to repay that portion. So just keep that in mind. So this isn't a deferment of rent for every month through January. Instead, it's a deferment of the rent that comes due during this moratorium period, which right now expires at the end of June. Okay, that's a good point. I want to make sure everyone was clear on that. So
I have a question just following up. Assuming that there's a problem at the end of this and that there is court action, how do you keep track of the non-rent payments for proof in a court of law?
So, well, you keep your general ledgers, so you know which months you mean. Is that what the question is? So
yeah, or what's going to hold up, with a judge, for the, I didn't get any rent here, and they owe us 7.5 months of rent.
Yeah, well, I think that probably is just your, and it's always a burden of proof on the landlord to establish they did not receive the rent. And typically, I recommend that clients do that with, have your standard rent ledger, and then if the tenant claims they paid the rent, then it's their burden, to overcome that and say, no, we paid the rent. That's their defense, and they'd have to prove that they actually did pay the rent. So, so I think the accounting is going to be more important or significant right now to show, look, if they pay the rent in July, that rent is applied to July and August and so forth, and that brings up another good point that if you do if you do reach an agreement with the tenant on a deferment or a rent repayment plan, try to get it in writing. So that's another way to document, any rent that's deferred, during this moratorium period, that it shows specifically which months it was, how much it was, and then that document could potentially later be used also in court as proof of the rent that's due or owed for those particular months.
I'm curious, Stephen, just briefly, and I wasn't part of any of this, but why did they change it kind of midterm here? Because it seems like they set down some rules that were pretty easy to follow, and now they kind of ripped them all up and started with something radically different.
Yeah, I think that, so there was some, I know there was some concerns about providing the documentation, and, the verifiable documentation. So the mayor probably heard some of the tenants crying about that, some of the tenants advocates complaining about that. And so they relaxed those standards. They say, well, they still have to have some sort of proof, but if they don't, then, that doesn't mean that they're not necessarily afforded the protections of the, of the moratorium. And then also, another significant change was the mayor came right out and made it clear that a violation of the order is a defense, an affirmative defense to an eviction for non-payment of rent. Now, I always interpret it that way anyways, but this just comes out and makes it more painfully clear. I would have never advised the client to proceed with an eviction, during that period anyways, but the mayor made that clear. They also pointed out a couple other things that they specifically came out, the mayor did, and made clear, you can't charge any interest or late fees. So there's just a couple of little things as well. And then also added the language. And so there may have been some, some repayment plans that were negotiated in the past, and those were in compliance with the mayor's order. Or maybe they weren't. Maybe the tenant agreed to a shortened period of time of 4 months to repay the rent. So the mayor came out and said, yep, no, this, these provisions cannot be waived. That was another new term I saw. So protections can't be waived. So you're going to have to give at least 6 months. So I think that clarifies that as well. And I've been telling clients anyways that you need to give them at least that 6-month period. But I can imagine probably there were some landlords out there negotiating shortened periods of time to repay the rent. So I suspect that probably some of the tenants' gripes were heard by the mayor, and then it was made part of the order to clarify those issues. So, okay, so again, the moratorium is currently set to expire on the 29th. The exception for moratorium, okay, so the exception for any type of eviction. So the moratorium basically says no evictions of any kind. So not only non-payment of rent, but including your owner move-ins, your temporary eviction to effect repairs, any type of relative move-in eviction, any type of an elective eviction or any other type of eviction in San Francisco is currently, precluded under the moratorium. You cannot proceed with any type of eviction at this point, except, here's the very narrow exception, evictions due to violence, threats of violence, or health and safety issues, or Ellis Act evictions. Those are the only exceptions I see. So basically your nuisance type evictions, or your your illegal use, not, if the tenant is illegally using the premises, creating a health and safety hazard, then those types of evictions can still proceed. So any other type of elective eviction, or possibly even non-elective evictions, like the tenant breaches the lease in some other regard. Maybe there's a no pet provision, or some other provision of the lease, and the tenant has breached that. Unless that rises to the level of being a violation of health and safety issues or violence, then you're not going to be able to proceed with an eviction at this point, at least through June 29th. So any type of a notice for these types of evictions cannot expire during this moratorium period. So it would have to expire after the 29th. I have a client who's been looking to do an owner move and eviction, and was looking to do so long before was planning to do so long before all these moratoriums went into place. Well, now the notice has to be timed so that it expires after June 29th. It's a little tricky because, again, that could be bumped out a month. So if we were to serve a notice now that expires July 15th, for instance, it would clearly be okay now, but if the moratorium period is extended, it may not be. So right now there's just a wrench in the whole eviction process and trying to time the expiration of eviction notices. All right, so we covered non-payment of rent moratorium and then other types of eviction moratorium as well. The only exception being violence or health and safety, or the Ellis Act. And the Ellis Act is, just in short, it's to remove an entire property from the residential rental market. And the only reason why that's still an exception is because that's a state law right, and the local government cannot impede that right. That would have to come from Governor Newsom. And at least I have not seen that at this point. So those are still accepted right now from the moratorium. All right, so rent increases. So we talked about the triggering of the anti-price gouging laws precluding rent increases above 10%. Well, San Francisco itself has also passed a moratorium on rent increases for units that are covered under San Francisco's rent control ordinance. So effective April 7th, the right to increase the rent under the ordinance is temporarily suspended, meaning you can't give a rent increase during this period. Anything since April 7th, any notice that has expired from April 7th going forward, and I'll give you the date in a minute, the expiration date, is going to be suspended. So any rent increases during this period, the increase would be deferred. However, at the expiration of this moratorium, a brand new notice would have to be served. So if you gave your annual increase and gave a 30-day notice that, let's just say it expired May 15th, that increase is not going to go into effect. You'll have to wait until after the moratorium expires, serve a brand new 30-day notice at that point, and impose your rent increase. So this defers it for longer than the moratorium period because you have to serve a brand new notice. The way it's written is this change will not, or this moratorium will not impact the anniversary date. So as you all know, when you give a rent increase, let's say May 15th, that is the anniversary date for future rent increases. So if you've historically had a May 15th rent increase date, and this, you gave one this year, it's now deferred. You give your notice such that it goes into effect, let's just say, September 15th instead, then the tenant would have to begin paying that increase on September 15th. And then your next increase could be given May 15th of 2021, because the way the law is written, it did not change the anniversary date. So now the expiration, the mayor signed this, I believe the mayor signed it on April 24th. I know it passed around the 22nd with the Board of Supervisors, but my understanding is that it was signed by the mayor on the 24th. So my calculation is that approximately June 23rd it would expire. So, roughly July 1st, for instance, you give your 30-day notice, and then effective, let's see, July, so effective August 1st, roughly, that new increase could go into effect. But you cannot give your increase until this moratorium expires. So I did have clients saying, well, can I give a notice now and time it so that it expires immediately after the moratorium? The answer to that is no. You have to serve a brand new notice after the moratorium period, so after June 23rd. All right, so any questions on the increased moratorium?
We don't have any questions on that matter, but we did have a couple last minute folks coming in who, and you briefly touched upon this, but this is the price gouging component. And I thought it would be warranted to have a little more detail there, because there's a lot of folks who are concerned about that. But if you can give us 2 or 3 minutes on the limitations in your opinion on what the price gouging regulations are and what that means specifically for, let's say, an owner had a long-term tenant who had vacated due to whatever reason, maybe months ago, maybe a year ago, and you fixed up the place, put in marble countertops, etc. What does that mean today?
Yeah. So, just again, a little bit of overview. The penal code, criminal law, imposes a moratorium on price gouging, no price gouging during a period of time following declarations of states of emergency by a government entity. We saw this a lot with the fires, up north. Over the last few years, there were states of emergencies that were issued, and the anti-price gouging laws went into effect at that point. And so now there's local states of emergency, and those trigger those same anti-price gouging laws, which essentially prohibit rent increases of more than 10%. So if you have a rental unit in San Francisco that's exempt from rent control, you are limited currently, in my opinion, to an increase of no more than 10% on your tenants. Similarly, when that unit comes vacant, so specifically what the law says is that when you can't serve a termination notice now, and then when the unit comes vacant, if it comes vacant during the moratorium period, charge the next tenant more than what you could have charged the prior tenant, which was 10% more than they were paying. So if the tenant voluntarily vacated, then my understanding is that the law would not apply. So what it says is you can't terminate a tenancy and then charge more than 10%. So arguably, if a tenant has vacated voluntarily, then you could likely charge the next tenant who moves in a rent that's commensurate with the market rate, even if that is more than 10% of what the prior tenant was paying. So it is, the law is written a little specifically that you can't terminate a tenancy now during the moratorium period and then charge more than 10%.
So just to reiterate, if it was a voluntary notice, your opinion is that there wouldn't be a 10% rent cap. Did I hear that correctly?
If the tenant voluntarily vacated, my understanding was, from the question, that they vacated prior to the moratorium. The anti-price gouging laws went into effect. It's a little bit more unclear if they vacated during and then charging more. I think that may be more problematic, but I remember this question came up, and it was that the tenant vacated prior to the moratorium, and then the landlord went in and did a whole bunch of construction to spruce the place up. I think in that circumstance, you could charge more than 10%. All right, so some proposed legislation. So we talked about the current state of affairs and laws and moratoriums, but those are what they are today. The moratoriums today doesn't mean it's what's going to be tomorrow. There's a couple that I'll just point out to you, some proposals, and one is Supervisor Preston's proposal locally, which says that, and this is a little difficult because it would substantially impact the landlord's right to ever collect the rent from the tenant, but it would prohibit a landlord from ever evicting a tenant for non-payment of rent if the rent was unpaid due to a COVID-19 related reason. And that would be any time between the period of the May 16th to May 31st, and potentially longer. That's going to be extended. And so what that means then is that you obviously get the benefits of that 6-month deferment. After the 6 months, presumably you could give a 3-day notice to pay rent or quit for that unpaid rent. This law, if it passes, would prohibit that, meaning you'd have to go some other course to collect that rent, small claims court, if it's less than the statutory amounts, or which I believe are $10,000 right now for individuals. An individual can sue for up to $10,000 in small claims court. If you're an entity or a corporation, it's, I believe, limited to $5,000. So if you're seeking rent in that range, you could potentially file a small claims court action, or if not, alternatively, you'd have to file a general civil lawsuit for damages, for rent damages. If this law passes, you then the landlord could potentially never recover that rent. So this will likely, I'm informed, I'm gonna get a little more information about this actually later today. I'm informed that this will likely be considered by the supervisors at some point this month. So stay tuned for that. And just FYI, San Francisco wouldn't be the first jurisdiction to have this sort of a moratorium. Oakland already has this in effect right now. Whether it's constitutional or not remains to be seen, but it's currently in effect. So over in Oakland, you can't evict for non-payment of rent, due to the COVID-related circumstances. So, and then at the state level, there is to nuisance or illegal use. But more significantly is the non-payment of rent aspect and a specific component. Just in summary, here's what happens. So under this law, if it passes, the landlord would conceivably be able at some point serve a 3-day notice to pay rent or quit for the rent that became due during a moratorium period. Again, this is if Supervisor Preston's law doesn't pass. If you are in court for a non-payment of rent case, then the court, the tenant could request the court for an order allowing the tenant to remain in possession because they were unable to pay the rent due to coronavirus. So let's say, for instance, May and June, or let's say April and May rent was due, the tenant didn't pay it. At some point, a non-payment of rent case is filed, and let's say you've complied with all the local laws and you're able to do it. If this state law passes, the court, upon request of the tenant, could say, well, yeah, you owe the rent. However, I'm going to allow you to remain in possession, and over, and you have to pay that rent back, but over a period of time. And in addition, for the next 12 months, while you're remaining in possession, the rent during this period will be reduced by 25% over that next 12-month period. I'm hearing that this doesn't have a lot of traction and hopefully won't become the law. But I know it's raising a lot of concerns because of a potential forced rent reduction in some circumstances. And that would have to go through the court system, and the court would have to actually make that finding and that order and allow the tenant to remain in possession. So it's not a foregone conclusion, but it is something to keep your eye on and potentially be concerned about at some point in the future.
Stephen, we had one question on that. And just to let you know, we've had a couple moments where you cut out, at least for me, and a couple of the guests have chimed in letting me know. So I'd encourage any participants to shoot me a Q&A if there was something that was missing. And, I'm sure we could talk offline if we needed to have any clarity there. But on the matter of the Mr. Assemblyman Ting's legislation, somebody is asking a question regarding a takings clause. What's your opinion on that? You mentioned you didn't think it had that strong of legs. Is there, from where you sit, is that a potential argument to invalidate that legislation?
Oh yeah, definitely. There's some constitutional challenges to both Preston's proposed legislation as well as Ting's. The problem is that you don't get those determinations until some point far in the future. So you may be subject to these laws in the interim, and at some point we may prevail and prove that it was unconstitutional for one reason or another. But in the meantime, the tenant has remained in possession and has only paid a percentage of the rent during that time, and you may never get that back. So yeah, there's definitely some potential challenges to that, and at least as with regard to Preston's legislation, I have seen some threatening letters to the mayor's office that if it passes, it will face constitutional challenges and lawsuits may be filed. And I'm sure similar type of threats are being issued to the state as well. So yeah, that definitely is in my opinion, at least an argument to make. But you just never know how a court may rule on these particular things, especially with the powers that the government has to enact these sort of emergency temporary laws.
Stephen, just to follow up on the Ting legislation proposal, does it only apply to non-payment of rent during the moratorium, or non-payment of rent at any time before or after the emergency order is in place.
So my understanding is during the moratorium period.
Okay. And I know we have some questions on commercial. I think you're going to get to that in a little bit.
Yeah, I think we're coming up on that next. Let's see.
Okay.
Yeah, so non-commercial non-payment of rent evictions. So hopefully we'll hit on those, get some answers to those questions right now. So let me just move this so I can be looking at the same thing. Okay, so there's some special commercial notice requirements. So the moratoriums don't only apply to non-payment of rent residential cases, or virtually all residential eviction type cases, but it may also apply, or does also apply, to commercial non-payment of rent cases. So when a commercial tenant fails to pay the rent, then the following applies. And this is actually similar to what the residential component looked like prior to the recent change. So the landlord must give, basically, so the tenant notifies the landlord of an inability to pay. The landlord must give the tenant a 30-day notice to cure. The tenant must pay the rent or provide documentation showing an inability to pay rent due to the financial impact related to COVID-19. And again, financial impact and related to COVID-19 are defined the same as they were defined for the residential context. So basically, the tenant can't pay. Landlord must give a 30-day notice to cure. The tenant then, that triggers the tenant's obligation to provide some sort of a documentation showing inability to pay due to the coronavirus. And upon receipt of that documentation, the period to pay is extended an additional 30 days. So the tenant now has potentially up to 60 days to pay that rent. During that time, the landlord is encouraged to approach the tenant and try to negotiate in good faith to develop a payment plan of that rent. And I'll talk a little bit about that. So even if no payment plan is reached, so you're attempting to reach some sort of a payment plan with the tenant. If it's not reached, then the tenant must pay the rent by the end of that extended 30-day period, or provide additional documentation to show that the tenant can't pay. So look, I still can't pay. My restaurant's still shut down, or I still don't have the income coming in. Here's the documentation. That extends it an additional 30 days. So this, again, it's a perpetual 30-day period. But these extensions cannot continue for more than 6 months. So the commercial tenant can get these sort of 30-day increments, but no longer than 6 months. After the 6-month period, the landlord can then give a 3-day notice to pay rent or quit. And this needs to this procedure applies to each month. So in April, the tenant makes the statement of inability to pay, and then provides documentation. Then again in May, they do the same thing. So for each month, you could sort of have this 30-day deferment period, or cure period first, and then a deferment period based on the production of evidence that the tenant provides to establish an inability to pay. This moratorium, nothing in the moratorium relieves the tenant of the obligation to pay the rent. The moratorium expires on May 17th. So this has been extended twice. I expect that it will probably be extended again. The mayor extended this in April to May 17th. And the mayor has in the past waited to the last day to extend moratoriums for non-payment of rent. So I would expect probably on or before May 17th, this period may be extended further. So at least through May 17th. So from March through May 17th, the commercial moratorium on non-payment of rent evictions applies. And that process of a 30-day cure period and then 30-day extensions based on the production of documentation to establish an inability to pay due to COVID-19. One interesting aspect is the landlord can use the security deposit to satisfy that rent, but the landlord can't then demand replenishment of that security deposit without complying with the same 30-day cure period and then 30-day extensions on inability to replenish that deposit by the tenant. So basically, there's really no reason to apply a security deposit, but it could potentially be applied. Perhaps if the tenant happened to be in the last month of their term, that may be a good opportunity to use it at that point. But that's unique to the commercial component for non-payment of rent. There's nothing in the residential component that says that the landlord can use the security deposit toward the non-payment of rent. So that is the commercial moratorium in a nutshell. Basically, they're going to get a 6-month deferment as well. And so you are encouraged to try to negotiate some sort of a payment plan with your commercial tenant.
Stephen, we do have a question on commercial, and I would just add before I pose it. I've written 2 articles in the last 25 days in addition to my newsletter for the Apartment Magazine, and covered some of this extensively. But management companies are reporting that almost all of their commercial tenants are needing a deferment of rent or a waive or a partial rent payment. So it is apparently very widespread, and the most impacted appears to be the commercial businesses that are shut down, restaurants, bars, things like that. So it is a real unfortunate development, but from those management companies that I've spoken to, essentially, their ownership, their clients, their owners are all working with these businesses. So something to note there. We got a question. This is assuming that the tenants are still paying rent, a commercial tenant. If there is a scheduled lease increase, based upon the contract, is that enforceable? Is there any prohibition against that during this order?
So, okay, so during for commercial, no, not for commercial, no.
Okay.
And you make a good point. My clients are doing the same thing. They're trying to work with their commercial tenants. I've prepared, quite a few deferment type of agreements, as well as even some temporary rent reduction agreements for commercial tenants. And that just sort of reminds me to remind you all that both the residential and the commercial moratoriums, again, they're not requiring rent reductions, but instead deferments. So it's not, again, not relieving the commercial or residential tenant of the obligation to actually pay the rent, but instead requiring the landlord to give the tenant a deferment of that rent for a period of up to at least 6 months. So I think that's an important component in when you're approaching your tenants who may be asking for a rent reduction, that you're not obligated to give a reduction, but instead you can give a deferment. One other component of the new mayor's order on residential non-payment of rent cases is that it comes right out and says that the landlord, as part of negotiating, can actually offer a rent reduction, and that would not be considered a reduction in the base rent. So I think that was another significant component that I saw that was new as of April 30th in the mayor's order. That was a concern of landlords that, hey, look, if I give a rent reduction, am I reducing the base rent permanently? And arguably, no, you weren't if it was done correctly. But given the new mayor's order, it comes out and it's a little more clear that it is acceptable at this point. It would not necessarily be considered a permanent reduction. That being said, you need to put it in writing and document it if you're going to offer a rent reduction, even though you're not required to do so.
Right. It should be noted, Stephen, as you are well aware, and of course, um, during the recent downturn, well, seems so recent, during the subprime mortgage crisis, that there were a number of tools of the trade deployed by some attorneys in town to temporarily reduce rents, um, so that a tenant wouldn't have to move out necessarily if the market showed that there was a $250 price reduction across the street for the same one bedroom. And a year or two later, when the landlord went back to reimpose that original base rent that was there prior to the downturn, the rent board eventually ruled those situations not enforceable. Am I summarizing that correctly?
Yeah, so the rent board has taken the position that if you give a rent reduction due to market factors, that is a permanent base rent reduction. If you offer reduction based on a personal financial issue with the tenant, so for instance, the tenant loses his or her job, or loses a roommate, and loses some income from that tenant, that co-tenant or roommate, then because it was personal to that tenant, the landlord can offer a temporary rent reduction, and then could potentially restore that rent back to what the rent was before that reduction. So you're not permanently reducing the base rent, but those are always dangerous. And I am glad to see that the mayor addressed that. And I have put together those agreements, and just followed as best I can the guidelines in the San Francisco of the rent board, to make it clear that it is not intended to be based on any market factors, but instead factors personally related to the tenant, such that it's not a reduction of the base rent. And this, again, it applies to residential. It has nothing to do with commercial. Commercial, you of course, you're free to negotiate a temporary rent reduction and then build that rent going back up at some point in the future. There's no restriction on commercial. That only applies to residential. All right, so we talked about the local moratoriums on evictions, residential and commercial. Well, courts right now, virtually nothing's getting done in the courts at this point. There's been, first at the state level, all pending unlawful detainer actions are continued by 60 days. So there's stays on all unlawful detainer evictions actions until at least, on new evictions, at least until August 30th. So pending ones are stayed by at least 60 days and probably more. New cases are stayed at least until August 30th. Basically, the courts aren't going to issue any summons or complaints on newly filed unlawful detainer actions. Again, the exception is health and safety, potentially violence. Those types of cases are accepted to the court stays. San Francisco, again, locally has placed a stay on all pending eviction actions through at least June 19th. Not issuing any summons or on new unlawful detainers and at least until June 19th, and probably longer. The exceptions, again, violence or threats of violence or health and safety issues. So the courts are virtually shut down for eviction actions. And even after these periods of time, if they're not extended even further, which they very well may be, even after those periods of time, there's going to be a pretty substantial delay in prosecuting any of these non-payment of rent or unlawful detainer cases, just because it's going to be overwhelming in the court system. And I've been telling clients, you're probably realistically on a new unlawful detainer action case, if you file that at any point after the moratorium period expires, you're probably not going to really get it resolved in the courts until the end of the year, maybe even 2020. And again, we're gonna have to see how it all plays out when the moratorium expires, but that's just me guessing at this point that there's gonna be a logjam in the courts when they actually do open up to these cases. And it's gonna just continue a lot of these cases far out into the future. So unless you have an emergency type matter that health and safety or violence are at issue, you're probably not going to get your cases heard anytime in the near future, which is, again, a reason why landlords should try to reach some sort of resolution with their tenants for a repayment plan over an extended period of time. All right, so we've sort of given a summary of what the various laws are, state, local, the court system, sort of what the environment is right now. So now we're going to sort of get into some of the practical issues. What I'm seeing when clients come to me with issues, that these are the significant issues and questions that I'm seeing. And the first, of course, being, what do I do when the tenant fails to pay rent? And I'm telling landlords to respond, try to be sympathetic. Look, we're all in this together. Everyone's been impacted. You're impacted. I'm impacted. Everyone's been impacted. Let's try to work something out. And a significant thing that I've been advocating is try to get something from the tenant. Okay, well, I understand you can't pay the rent this month. How much can you pay? How much can you pay at this point? And whatever amount you can't pay, then let's work out some sort of a forbearance agreement, a deferment plan over a period of time for you to repay that. So trying to get some rent. And I've had a lot of clients who've been successful and have gotten something. Not uncommon that the tenants pay half. I've seen a lot of tenants offer to pay half, and then the other half is deferred. And there, at least you got something. If the tenant's willing to pay it, take it. And then work out some sort of a repayment plan for the balance. And again, comply with all applicable laws. So you're going to be required to give at least 6 months. You may as well offer more time, in consideration for the tenant paying something. The other half, they'll maybe pay back by, sometime in January or February. And so you're working out a plan. And again, you're not required to reduce the rent, but instead to defer it over a period of time. So I do recommend that you try to negotiate with the tenant as a deferment plan. If you're inclined to offer a temporary reduction, well, given the mayor's order now saying it's not going to be a reduction in the base rent, perhaps you're willing to do that and to risk that. And if so, then again, document it. So if possible, document any deferment and document any reduction, temporary rent reduction. And by document, I mean present a written agreement to the tenant to review and hopefully sign that documents that deferment or temporary rent reduction. I think you're going to be in a much better position if you get that documented in writing by an agreement. That being said, the tenant, you can't force the tenant to sign anything. You can't make them sign a forbearance agreement. You can't condition the 6-month deferment on the tenant's signing a forbearance agreement. So the tenant may refuse. But if you approach the tenant in a sympathetic way, I have seen the tenants, willing, sympathetic and saying, let's work together to resolve this. I have seen tenants sign agreements and be more inclined to do so in that circumstance. But again, I keep hearing rumors that there's going to be rent strikes, and I hear also not even rumors. I see it on tenants advocates' websites saying, don't sign forbearance agreements, or if you're presented with one, bring it to a tenant attorney. So probably I'm expecting more and more tenants may refuse to sign them, or may just refuse to pay rent because they can at this point. So again, just try to be sympathetic and work with the tenant and get something out of the tenant if possible. And then try to document everything in writing and get the tenant to sign some form of an agreement if possible. All right, so Matthew.
I have one question here from somebody, just briefly, along the lines of a forbearance agreement, and this is a lot of hypotheticals, but we're hearing from you now that the tenant advocates are suggesting not to even sign these. But let's assume you have one in place, and on the 5th month of the term of when it should start, or they vacate the property.
Yeah.
Looking forward, what are folks to do in that circumstance?
So yeah, that would then, remember these moratoriums apply to non-payment of rent. So if they just simply up and leave before their obligation to pay that rent comes due, then that automatically triggers your rights to collect it through general civil litigation. Obviously, you're not going to be able to give a 3-day notice to pay rent or quit because the tenant's not in possession anymore. But at that point, then one, you have your security deposit. So I would use that. And then two, do what you normally would do when you have a tenant who's skating on rent or leaves a place damaged. You send your security deposit disclosure or disposition statement, and then a demand for the balance of whatever's due. And maybe small claims court on that if it's within the legal amount, or general civil litigation. Okay, so so that's the main question I'm getting is, what do I do when the tenant doesn't pay rent? Another question I get is, what do I do when the tenant is creating a nuisance or is violating the stay home order or endangering other tenants? An example I give is, you all remember the spring breakers back when the stay home orders first started being issued, and this this seriousness of the COVID-19 was becoming more and more prominent. And you have all the spring breakers out in March on the Florida beaches partying and in close proximity to each other. But what if you have a young or anyone really at home, staying home, and then having people over and throwing parties and violating the stay home order in a multi-unit building and endangering potentially other occupants or residents of that building? Well, remember, the landlord has an obligation to provide a quiet quiet enjoyment, peace and quiet to the tenants or residents of the building. So to the extent that someone is violating stay home orders and compromising the quiet enjoyment or health and safety of other tenants in the building, then the landlord better do something about it. And that may be in the issuance of warning notices, or remember, the exception to evictions at this point are, evictions for conduct that is detrimental to the health and safety of others, or even violence. This particular circumstance would potentially rise to the level of creating health and safety issues. So you could potentially evict the tenant in that circumstance, but at a minimum, take some sort of affirmative steps to address the situation. Let the tenant know of the severity or consequences of that conduct, and do something about it to prevent it. Because if you don't, if someone gets infected in the building, guess who they're going to come after and blame?
Stephen, can you hear me? Okay, it seems to have been interrupted. I'm going to jump in here. There's a couple outstanding questions, and then I thought it would be helpful if you are able to hear this, that we kind of go over the recent change that occurred specifically to residential tenants, and the proof of documentation, and the proactive notification of the owners of their inability to pay rent. Hoping you can hear this, Stephen. We have a question regarding it's a large house, and the owner would prefer to rent to families and not to roommates because of COVID-19. Would that be permitted to advertise it in such a way? And sorry.
Can you hear me?
I can hear you now, Stephen.
Okay. So to answer that question, I would not place any limitations on a group of tenants. I would not say put anything in any sort of listing or advertisement that you're only renting to certain groups, like a family, for instance. or any preference, because you may run afoul of some discriminatory laws, anti-discrimination laws, by preferring a certain group of tenants. Perhaps a group of roommates comes in and they're an ethnically diverse group, and you say, no, I'm not going to rent to a group of tenants, then that could potentially run afoul of discriminating against certain characteristics or classes of people. So I always am very cautious about advising clients on advertisements and placing preferences on any specific group of tenants. So can you still hear me?
Yes, we could hear
Okay,
you.
good.
And then going back to, I guess, if the Preston legislation goes forward regarding the missing rent, say it's a LLC with 3 members who are participants in the ownership group. Could all 3 of those go after the $10,000 limit? Or, let's assume the outstanding debt is $20,000 and there's 2 owners. Could they each go after to try to recover the lost rent in small claims court?
Probably not. No, no. I have seen landlords in the past assign the rights to rent to an individual, and then go into small claims court based on that assignment. I've always been a
Sorry, Stephen, you're breaking up again. I'm assuming nobody can hear Stephen.
the statute of limitation, then that may be problematic. But I would say definitely certain members of that organization separately filing lawsuits to get around that limitation is probably not going to fly.
Okay, and I'm going to just get to 2 other questions, and then I think we're almost out of time here. But going back to Assemblyman Ting's legislation proposal, if the rent is reduced by 25% and it becomes the new base rent for future anniversary dates for allowable rent increases. I mean, it's kind of esoteric, but also would the 25% rent reduction by the court apply only to non-paid rent during the moratorium, or the ongoing rent after the moratorium for the coming 12 months?
Yeah, so you remember this is very specific in a pending unlawful detainer case. The court has the authority to allow the tenant to remain in possession and reduce the rent per court order over that next 12-month period. So to answer the question, in my opinion, no, it would not reduce the base rent, because it would be an order, a court order saying, tenant, you can remain in possession over the next 12 months, and the rent would be, or the unlawful detainer damages, or rent basically, would be reduced by that amount over that period of time. So I think you would probably be able to avoid an argument of a base rent reduction. And yes, it does apply to the rent over prospectively, so over a 12-month period going forward. Yeah, so it would apply to that.
And then we have a question really about going back to proof of evidence of impact by COVID-19. And I think we had a lot of these questions 2 or 3 weeks ago, or a lot of owners were concerned when I wrote a couple of articles on this topic. But what if a tenant has a bunch of savings? Is there any, there's frustration on the part of a lot of owners because, you might not have a job, but you might have, 10,000 shares of Apple.
Yeah, nothing that I've seen allows a landlord to go and say, well, you can use your 401k or your savings, or, what money you're going to be getting from, from the feds, the CARES Act money. You can't do that so long as the tenant has established an adverse impact, and, as that term was defined, then they're going to get that deferment, and you can't really force the tenant to look to other sources to pay that rent. All right. So, Matthew, I have a few more slides. I know we're running out of time. I'm happy to wrap it up here or just answer any questions, whichever you prefer.
I'm happy to push on for a few extra minutes. Yeah.
Okay. I'll go through them quickly. Okay. Okay. Entry to units. That's another question I'm seeing a lot. And right now, I'm basically just telling clients to, you do have a duty to provide a habitable premises, but if it's not something that is, rendering the unit uninhabitable or really affecting a health or safety issue, defer it. Just defer it if possible. And a lot of times what I tell clients is put the ball in the court of the tenant. So look, this issue has come up, there's some peeling paint or whatever. I'm, due to the circumstances and for health and safety reasons, I'm suggesting we do this after the stay home orders and after, some of these emergency restrictions have been lifted. And do you agree, tenant? If not, I'll come in earlier, but let's defer it. And across the board, I'm seeing the tenants say, yes, let's defer it. I know some of the lifting of the moratorium does allow for a little greater leeway on landlords to enter units, do construction or do things. But again, if at all possible, just defer it. If it's something that's essential, then of course, get in and take care of it. Otherwise, defer it or work with the tenant to come up with another period. Maintaining the property. Again, this is an issue that's come up is the landlord may be extra vigilant now in maintaining common areas, cleaning and disinfecting them, notifying tenants of, the obligations to, stay home, and also, to implement practices to, maintain proper hygiene, washing hands and things like that to prevent the spread of COVID-19. So just letting the tenants know that you're taking steps, and also reminding them to safe distance from other residents in the building and just respect the quiet enjoyment of other people at this time. And if a landlord is notified of a tenant infected in a building, maybe take extra steps to ensure the clean and safety, the cleanliness of the common areas, notify the other residents that, hey, there has been an infected resident in the building, stopping short of letting them know who it was. You want to be careful because you may implicate some medical privacy issues. So taking those steps and then reminding tenants again to do everything they can to, avoid, coming in contact with other people in the building. This was a slide that I added since the last one we mentioned, the last talk that we had with, again, force majeure. Some provisions in leases may allow a tenant to break a lease in the event of basically an act of God or a natural disaster, things like that, war. Well, the pandemic may also trigger that. Look to your lease to see if there's a provision, because I do see cases, commercial and residential, where tenants are trying to breach leases and saying that the COVID-19 situation has rendered performance impossible or impractical under the lease. Look to the lease agreement to see if there's a provision that may trigger that right of a tenant to do so. The CARES Act, again, provides some relief for property owners. You can look into that to see, well, hey, my tenant's not paying rent. How do I get compensated? What can I do? There may be some form of relief under the CARES Act. Also, we talked about the state and local moratorium on non-payment rent evictions. There's actually a federal one as well, and it applies to general federal subsidized housing, but it may also apply to FHA loans. If you have a mortgage that's an FHA mortgage, then this additional protection, the moratorium on non-payment rent, may apply to your situation. And that was it. So I kind of sped through those last couple ones. Were there any final questions, Matthew?
Yeah, there's a few final questions. Stephen, it would be really helpful just if you could refresh everyone the recent change that occurred and then I'll ask the last two questions. But, you know, primarily we were all operating under the assumption that these were the rules of the game, and then they just changed a couple days ago. If you could talk on the 2 or 3 main points of that.
Yep. Yep. So the tenant, one, is required to give notice of inability to pay due to COVID-19. So financial impacts related to COVID-19. That's one. There's no longer a requirement that they do so within any certain time period. It's just inability to pay during the moratorium period. Two, they are supposed to provide actual proof of inability to pay, but that has now been relaxed. If the tenant does not provide it, they still could have the benefits of the, the basically rent deferment, even though they did not provide the landlord with proof of inability to pay. In the past, it was the landlord was supposed to receive this documentation within a certain period of time, and it had to be objectively verifiable. That's no longer the case. What it is if the tenant does not provide it, they still get the benefit of a 6-month deferment on their obligation to pay the rent during that period of time. And they can then provide that information or documentation to a judge in a non-payment of rent case for rent during that period. So it's really going to be very risky for a landlord to proceed with a non-payment of rent case based on the tenant not providing the tenant with the landlord with verifiable information, because the tenant can provide it in that non-payment of rent case. So basically, tenant gives notice of inability to pay. In my opinion, at that point, the landlord then needs to work with the tenant on the repayment of that rent, but it can be no sooner than 6 months after the expiration of the moratorium period, which is essentially the end of June. So the tenant will have up to basically January 1st, roughly, to pay that deferred rent. And the landlord will not be able to do a non-payment of rent for the non-payment of that rent during that period of time. But
the tenant does have to present at some point a notification to the owner about the situation that they're in.
They do have to provide notification of inability to pay. What has changed is their obligation to provide proof of it.
Okay.
That has changed.
Okay. Last two questions very briefly. Somebody was asking regarding a sample letter regarding tenant safety in a building, in reference to, I assume, COVID and distancing. I suppose the local association, San Francisco Apartment Association, may have a form like that. I don't know, Stephen, do you have anything like that?
I'm not aware of that agency having that sort of a letter. I have prepared one with some bullet points that I've given to my clients for, situations where sort of a building where there has not been a COVID-related infection, and then one for after. So I do have sort of 2 bullet point letters that I have.
Great. Well, I think that's really it. Stephen, I really appreciate your time. It seems like we had a pretty good turnout today. It almost seems like we should probably be doing this every 2 weeks because it's changing so rapidly.
You might be right. Yeah.
And I really, feel free to reach out directly to Stephen. His email's listed right there, swilliams@freedwilliams.com. They have offices in Oakland and San Francisco. And, I can say in parting that, it is a tough time for everyone. I think the term that Stephen used a couple times, work things out, figure out a solution that can work, is key here. Our hope is that in short order, we'll be through this and back to a more normal lifestyle and then more normal economy. But there are going to be some major hurdles ahead. And I really appreciate all your time today, and Stephen, especially you. Thank you very much.